All right, so we're at the 2018 NELA conference, National Employment Lawyers Association conference in Chicago. And we just went through a session on trials of FLSA cases. And some of the things that they covered today were checklists that start out a month before, 2 weeks before, day of trial, and typical day-to-day layouts. And it includes things like waking up at 6 a.m., doing your motion practice, trying the case, what to do after trial, rest, sleep, lots of complicated checklists. But Bill, what do you think is the most important part in trying the Fair Labor Standards Act case?
Be prepared, number one. Tell the truth, number two. Remember the other side is more nervous to hear your testimony than you'll ever be to say it.
True.
They're scared. They're counting on you not wanting to go forward. And when you understand that, it's easy.
It's easy, right?
Very easy.
So I think lawyers overanalyze things, and we hate to fail. So there's a lot of checklists and a lot of, I think, overproduction. We make things more complicated than they really are. And sometimes that affects the court too. Judges think that we have to go through a lot of hoops, and the level of proof is really complicated. But at the end of the day, I think it's just authenticity, people's testimony on the hours they worked and what they did.
I totally agree. I go by the philosophy of the KISS philosophy, keep it simple, stupid. Did you work overtime or not? Were you paid for it? And let them try to prove you wrong if in fact it's not true.
What do you think about class representative? Some people think it's a big responsibility. It's like, wow, I represent the entire group and I have to testify for everybody. How do you address that type of concern?
Well, everybody that's been a class representative is usually pretty happy at the end of their case. People are going to come up to you and thank you for leading, for starting the lawsuit, allowing them to jump into the lawsuit. So I don't think there's very much pressure at all. I think people are very grateful for you to do that.
You know, when it comes to trial, people always wonder, well, what type of evidence do I need? Can I even join a class action overtime case if all I have is a couple of paycheck stubs? Now that we sat through this seminar, listened to other lawyers talk about their trial strategy, what level of proof do you think someone needs before they can join an overtime case?
I think all they need is their knowledge of what they did in the job and their testimony, their strength in numbers. You're going to have tens or hundreds of other people backing up your testimony, and it's our job as the lawyers to get the documents. All we need from you is your knowledge about your workplace and how you were paid.
Some of the things that was covered in this seminar were expert witnesses, summaries of payroll records. Can you tell them what that means? What are the roles for experts in a Fair Labor Standards Act case?
Well, I think the role of an expert is just to keep it simple, to clearly explain to a jury or a judge what all the documents mean, and relate that to your testimony.
You know, one thing that a lot of people are concerned about is, do I have to go through each week and testify about how many hours I worked? And I think that the important thing is that you know that the judge and the jury, they don't want to listen to that either. They don't want to hear 14 people testifying about the wages, the hours, and the job duties. So at trial, eventually it'll be summarized into a shorter period of testimony or less people. Not everybody that joins an overtime case needs to testify. You agree, Bill?
I totally agree, and no one's ever going to ask you, did you work 47.1 hours in a certain week? You just need to generally know, I came in at 8 o'clock in the morning and I generally left at 6 o'clock in the morning, and sometimes I may work as late as 9 o'clock. Keep it simple, keep it general, and that's all you have to testify about.
Keep it simple, right?
Keep it simple.
All right.